to major in political science.
Hi, my name is Ella Avlar, and I'm planning to major in business.
I'm Olivia Gallardo, and I plan on majoring in psychology.
I'm Ellie Lynn, and I plan on majoring in biochemistry, and these are our two coaches, Mr. Takahashi and Mr. Giuliano.
Awesome. Great. And so, the question this morning, well, for us, it's question B. These two clauses, the Establishment Clause and the Free Exercise Clause, are frequently in tension. Yet, we have long said that there is room for play in the joints between them. What are some of the ways the First Amendment's religion clause have been in tension with one another? In your opinion, have recent Supreme Court interpretations of the Establishment Clause strengthened or weakened the protection of religious liberty? Explain. And should the federal or state governments implement additional laws offering more robust protections for religious practice? Why or why not? You may begin.
No man by nature is bound unto any particular church or sect, but everyone joins himself voluntarily to a society in which he believes he has found that profession and worship which is truly acceptable to God. John Locke. Freedom of religion is a cornerstone of individual liberty and social unity, grounded in values that champion autonomy and human dignity. John Locke's letter concerning toleration asserts that belief is inherently personal and can't be forced, reinforcing that true faith stems from free will, affirming natural rights, and ensuring no belief system controls the conscience of others. This protection lies in its ability to ensure that individuals can worship or abstain from religion without fear of government interference. The case Church of Leukemia v. Hialeah highlights this principle, ruling that laws targeting specific religious practices, such as animal sacrifice, cannot discriminate against particular faiths. While restrictions on religious practices may be acceptable in cases of public safety, they must not target specific religions. This freedom not only safeguards individual identity, but also strengthens the societal framework of a pluralistic, democratic society.
Living in a country where you can freely exercise your beliefs is truly a privilege and essential for people to express themselves. However, in a country where roughly 66% of our population identifies as Christian, a clash often occurs between the Free Exercise and Establishment Clause. Whether it's the 40-foot cross in Maryland honoring soldiers from World War I, Bible-based curriculums, or the 10 Commandments plastered on school walls in Oklahoma, major concerns have come to surface regarding when a person or group freely exercising their beliefs violates the Establishment Clause. In Engel v. Vitale, the Supreme Court ruled that public schools in New York reciting a Christian prayer violated the Establishment Clause. Those students were freely exercising their beliefs. It resulted in people of other religions feeling excluded, and that's where the limit should be placed. As stated by Justice Hugo Black, the Establishment of Religion Clause was intended to prevent any one religion from becoming favored and to ensure that minority religions are not discriminated against.
The Supreme Court has greatly strengthened religious liberties through the weakening of the Establishment Clause in their recent interpretations, although they historically stood on three lines to protect the balance. Those being 1, your right to believe is absolute, your right to act on that belief is not. 2, if you impact others' rights, it can be regulated regardless of religion. And 3, the government can't use their power to promote religion. They've switched the narrative, trying to fight against the war on Christianity. In Masterpiece Cakeshaw v. Colorado, it established the idea that religion is a permission structure that allows moral claims against civil rights law. Even though Colorado was protecting the rights of the LGBTQ, they ruled in favor of religious interest, abolishing the lines the High Court once stood on. Kennedy v. Bremerton also strengthened religious liberties, allowing a public high school football coach to express his religious views, ignoring Establishment Clause concerns, as well as overturning the Lemon Test.
With the court weakening the Establishment Clause, permitting additional protections for religious practices would undermine equality. Attorney and journalist Andrew Seidel explains the nuance best. Parity is not oppression. Equality, even when it means the erosion of privilege, is not discrimination. For instance, religious objections to vaccinations create disparities in public health. Such exemptions do not promote fairness, they enable privilege at the expense of the collective good. While strides to combat this imbalance, like the promotion of the Do No Harm Act and state-implemented RFRA variations exist, the core issue lies within our national government. The current conservative majority has become even more pro-religion, undermining decade-old precedents and diminishing the founders' beliefs of a secular and godless government. A 2021 survey by the Pew Research Center found that our lawmakers are more religious than the American public, resulting in decisions for religious exemptions. No matter the additional protections, there will be no meaningful change when our government is built upon a foundation cracked by religious bias.
Thank you.
So the first question, why did the founders include the religion clauses in the Constitution?
So they included the religion clauses in the Constitution because if we look at Thomas Jefferson, in his personal library, he had many religious texts from the Quran to, the Bible and other religious texts. And they believed heavily that other religions, no matter what they are, have stuff that have value to, give, and different viewpoints is beneficial for the United States.
Yeah, religion has always been a cornerstone for America. It's always been, ever since the early colonies. I mean, religion in the early colonies is completely different from how it is now. Each state had its own religion, but it's always been a factor, and especially in the government. And so I believe that the founders and the framers included that in our Constitution to ensure that no majority religion, like how we see now in our government with Christianity, is persevering and ensuring that minority religions can prosper and freely exercise their beliefs.
In your testimony, you spoke about the government being godless. Going back to, do you believe that the under God provision in the Pledge of Allegiance should be allowed to be stated in public school? Do you think that goes against the Establishment Clause?
I don't think it goes against the Establishment Clause because under God is very subjective. People consider different things God. For example, I consider Jesus Christ God, but other people consider Satan God, or they consider themselves God. And so it came at a time during the Soviet Union, or during the time where they were combating the Soviet Union during the Cold War, because the Soviet Union was essentially an atheist country. And so many concerns arose as to whether or not they were trying to talk about a specific God, like the Christian God. However, I think that it's, since it's so neutral, I think that that's how we're able to say it to the point that it's not violating the Establishment Clause.
Yes, if we look at things like "In God We Trust" on our dollar bills and stuff, it's become non-secular. And even Christmas trees. There was a 60-foot Christmas tree in front of the United States Capitol building. And, that screams Establishment Clause in my head because I view Christmas trees as a Christian symbol. But it's become non-secular and just, celebrated widely by non-Christians as well.
To what extent should the Free Exercise Clause protect religious practices that could harm others?
Well, I think if it harms others, it shouldn't be protected. A bill was proposed to essentially check the RFRA called the Do No Harm Bill. And it essentially means that you can't use religion or you can't use the RFRA to justify discriminating against another person. And I think that is entirely where the line should be drawn. If you infringe upon another person's rights, even if that is in the name of your religious belief, that should never be allowed.
Yeah, and especially during times of COVID-19, many people were opposing vaccination mandates and wearing their mask or religious gatherings because they didn't want to, because they were claiming that it was against their religious beliefs. However, in the New York State public health workers case where people were essentially like going against the vaccine mandates because of their religion, the government or the courts ruled that they were going to prioritize public safety over people freely exercising their beliefs. And so I think that's the way that we can really see how the courts have really balanced that harm to the public and freely exercising.
Yeah, I definitely agree with my colleague Olivia, and just to kind of bounce off of her with vaccines, religious exemptions such as vaccines, they lead to things like vulnerabilities and herd immunity, as seen in the 2019 measles outbreak in New York. And if we look at the case of Employment Division v. Smith, it is ruled that laws generally applied to all individuals, regardless of religious beliefs. It does not violate the Free Exercise Clause.
Anymore, going back to our testimony in cases like Masterpiece Cake Shop or 303 Creative LLC, that allows the permission structure of religion against civil rights law. In 303, the owner of the website was able to deny a marriage website for an LGBTQ couple just because of her religion bias. And many Christians believe that their own personal right to free exercise comes amongst that.
And for the next question, to what extent should the Free Exercise Clause protect religious practices that could harm others? Oh, I'm so sorry. Let me try this again.
Can you give an example of the tension between, which you've given some already, but additional ones, of the tension between the free exercise and the establishment clause when it comes to local government, the application of the two?
If we look at, Washoe County, they open town halls with, different religious prayers. And they make sure to include a different religion, every time they open. So it's not specifically just Christianity opens every time. Like we've seen in Greasby Galloway, where that did happen, and town halls, they ruled it to be, not establishment clause, as they weren't coercing others. Even though that they may have led with Christian prayer every time, it is open to others to, introduce prayer for the town hall.
So I know you guys talked about Engleby Battalion. Do you think that moments in silence in public school strikes the appropriate balance between the establishment clause and free exercise clause?
I think it does because it's neutral. I mean, the 30 seconds of silence used to be 30 seconds of prayer, and that was most definitely a violation of the establishment clause because it made people, especially who weren't religious, feel excluded. And so during that 30 seconds of silence, some people pray, people think about completely different things, and so it's completely neutral, and so I don't think it's a violation of the establishment clause.
I'd agree with my colleague Olivia. In Everson v. Board of Education, it was a requirement to read Bible verses every morning before class started. And the court ruled that was a violation because you're enforcing and you're promoting a specific religion upon others. The 30 seconds of silence allows students to practice whatever religion, whatever belief, or whatever other usage of that 30 seconds that they want.
Specifically looking at Kennedy v. Bremerton, which was mentioned in our testimony, in the dissent, they bring Engleby Battalion, and in the sense that allowing silent prayer, even like Kennedy did, kneeling on the field and having students gather him, that he didn't coerce into praying, but he was still praying on a public or government issue football field, basically. And that creates an imbalance where it's still establishment clause concern, and I agree with the dissent.
Yeah, I definitely agree with my colleagues, but kind of just to give it a different perspective, especially in the school setting, I think a solution to this would be to kind of give students or faculty that kind of outlet to freely express themselves without endorsing on other people through things such as clubs. And I'm saying this because our school district, the Clark County District, had violated things like the Equal Access Act, the Nevada Constitution, and the U.S. Constitution due to ongoing bias against a Catholic student's creation of a pro-life club here at ESAC in Las Vegas. And the regulation on discrimination for school clubs is that discrimination for religion, politics, philosophy, or other kind of speech-based content is prohibited. And the Equal Access Act also ensures inclusivity and fairness by providing students equal opportunities through things such as clubs and organizations. So I think that kind of, or the Equal Access Act for things like clubs is the perfect kind of outlet to maintain that kind of neutrality in schools.
Let's try this again. How might the free exercise and establishment clause questions come up in the context of local governments? Wow. Someone say so. Obviously, you'll see. My apologies. We'll try this once more. And then we'll just have to check with my colleagues here. Okay. Should it violate the establishment clause for the state to post copies to the 10 Commandments in all school classrooms?
I think it is a violation of the establishment clause, especially when it's serving a religious purpose. We see in McCreary County, the ACLU, where 2 courthouses and 2 schools were putting 10 Commandments on the walls, and it was very clearly serving a religious purpose, in contrast to a case such as Van Orden v. Perry, where the 10 Commandments are on the grounds of the Texas state capitol, and that is serving a more historic purpose. And so I wouldn't say that that is a violation. It really comes down to the intent, but usually the intent is to serve a religious purpose and to really showcase Christianity.
While I do believe it is a violation, I think it's important to understand that if you allow one, you have to allow all. In Oklahoma, they attempted to build a 10 Commandments statue in the Capitol, and when a group, the Satanic Temple, tried to challenge this by also building a statue of Satan in the form of Baphomet, Christians believed that this was a complete violation and it was disgusting. But you can't just favor one religion and not favor anything else.
even more if we look at if you allow one, you must allow all. In Texas, a chapel and other religious institutions were putting banners and posters in school. And the Church of Satan had challenged Governor Ron DeSantis, and they applied to put in their own posters and banners saying, Satan loves the First Amendment. And they refused to recognize that religion, just furthermore establishing Christianity in the schools and not allowing others.
You guys did amazing. I was really blown away by your guys' use of local current events, and for nationally and locally. I thought that was incredibly impressive. I think we can all, it's first thing in the morning, we're all nervous, we can all take a deep breath, slow down just a little bit, but I was really blown away. Nice work.
And for my part, it's very obvious you guys can prepare, and you guys really were able to equally cross board, spread your talking time, so kudos on that. And aside from that, I don't have much else to add.
Excellent job. Oh my gosh. You guys knocked it out of the ballpark. Your answers were absolutely responsive. You used evidence for every response. Great evidence. You used current events, historical events. You used precedents. You used local. I love that you mentioned the Clark County School District. You mentioned Washoe County. I mean, you guys really did a great job on this question. Great eye contact. I thought your prepared remarks, well done. You could slow down a little bit, but, and I don't know, I guess you can ask your timekeeper how much time you had left with your 4 minutes. Maybe you can't in order to get all your content in, but if you have time left, then try to slow down a little bit. You all have your own personalities. I loved, Ali, you were heartfelt in your answers to some of the questions, and even with your prepared remarks, great eye contact. You clearly memorized, what you were going to say. Olivia, just it seems I think you answered every question, which is fine. All of you, Ella, great responses. I wrote down, granted, I know the teachers want that. You can't read my handwriting. My notes would be useless to you because I just scribbled all over the place. But I just thought I have excellent response, after Olivia responded to something, heartfelt after Ali responded to something, great references to evidence and cases. I loved that you guys, when you all responded to answers, you all added something different. We want everyone to participate, but not just for the sake of saying something, but saying something different and adding something to each answer. And you guys did that. I mean, I don't know what you could do different. I thought you guys were great. Way to start the morning off, man. You set the bar high today. Yeah. Good luck in the next round.
Thank you guys.
Good job.
Thank you.